Hello, and welcome to our mid-year review with compliance. In light of ERISA's 50th anniversary this year, we've titled this one ERISA, How It Started and How It's Going. We hope to provide information on both some old rules and some new developments under this law. Here are our speakers for today, and I think it's a significant testament to the importance of ERISA that we still all call ourselves ERISA lawyers in 2024, although really we do so much more than that. So to start things off, I'm Andrew Malachowski, and I'm the head of the compliance team for Gallagher's South Central region.
And I'm Sally Weinman. I lead the West Region compliance team for Gallagher. All of our regional teams work with clients across our regions and our Gallagher account teams. And we're really here to help you all understand and implement all the group health plan compliance obligations. And that list keeps growing. Even the old ones, we're adding new while we're talking about the old ones.
And I'm Kim Mitchell, Division Vice President, and also part of our sort of national team that supports the compliance consultants throughout the country. And I'm going to get us started giving a little background on ERISA. This is not new information, but good to review the rules once in a while. So just starting with a little bit of history, to understand why employers and plans are subject to the rules that we're about to discuss, it's really important to understand why ERISA exists in the first place. In the decades before ERISA, employers often offered health or pension benefits to retain their workers. And in those days, the workers often worked for decades for the same employer and were promised that they'd have health care for life or a pension for their retirement. But because no true standards existed for these benefits, they were considered gifts and could be taken away without much consequence. So eventually, this came to a head when a car manufacturing plant closed and the employees lost their jobs. And it was discovered that plan officials had taken much of the funds for their personal use rather than securing those promised health care or pension benefits. So in time, this led to the passage of the Employee Retirement Income Security Act on Labor Day, 1974. And Congress's purpose for ERISA is clear. The requirements under ERISA are to ensure employees are informed about their benefits, to report plan information to the government, and to establish a set of standards that govern how to administer the plan, and those are the fiduciary rules. And finally, ERISA also provides an avenue for participants to seek remedies in federal court, and it preempts states from involvement in regulating most aspects of ERISA plans. Retirement plans were the main focus of ERISA because retirement plans generally hold the bulk of participant assets, but ERISA does also regulate health and welfare plans in many of the same ways. And obviously that's what we will be discussing today. And as we move into the rest of the presentation, this history and purpose are important to keep in mind because they help us to understand why employers and plans are subject to these rules. So we'll talk for a few minutes about the scope of coverage, meaning who's covered and what types of benefits are covered. And again, these are basic rules, but a refresher is always a good idea. For the purpose of health and welfare plans, ERISA applies to employee welfare benefit programs. An employee welfare benefit program is a plan, fund, or program established or maintained by an employer for the purpose of providing specifically listed benefits, insured or otherwise, to participants and beneficiaries. To determine whether ERISA applies to an employer's program, we must first look at who is an employer under ERISA, and second, whether the type of benefit is one of the benefits specifically listed in ERISA. First, let's look at the employers subject to ERISA. Under ERISA, the term covered employer is defined to include employers engaged in commerce or in an industry affecting commerce, or employee organizations, meaning unions, who represent those employees. So in plain language, this means all private sector employers. It does not matter the form the business takes. It can be a corporation, an LLC, an LLP. It can be for-profit or not-for-profit, closely held, or publicly traded. And the definition includes these employers regardless of their size. So it applies whether there's one participant or 10,000 participants. And this is important to remember because employers sometimes mistakenly believe that they're not subject to ERISA requirements because they're a small employer. And this can be confusing because there are some laws with an exemption for small employers, but ERISA is not one of them. ERISA does have some exemptions, though. There are some employers who are not subject to ERISA, and they include church employers, which can include a convention or association of churches that sponsor a plan primarily for the benefit of church employees, and governmental employers, and this includes Indian tribal governments. Employers subject to ERISA also have to consider whether other employers will participate in their plan. It's common for employers to want to band together for economy of scale and to allow risk to be spread across the larger organization. But not all employers can group together to create a plan, so employers need to carefully consider which other employers may participate in their plan. Under ERISA, when more than one employer participates in a single ERISA welfare plan, those employers must be related to each other, or it will create what's called a multiple employer welfare arrangement, or a MIWA. Internal Revenue Code Section 414 provides rules for determining whether the employers are related, and these are called the controlled group rules. The controlled group rules help determine how much common interest the employers share. Generally, to be in a controlled group, each employer must have at least 80% common interest. And at times, the controlled group status will be obvious. For example, like we have up here on the slide, suppose there's a corporation, Lion Corporation, and that entity owns two subsidiaries. We can call them Tiger Company and Bear Company. And in this example, Lion owns 100% of both of those subsidiaries. Because that interest exceeds 80%, Lion, Tiger, and Bear are in a controlled group and can participate in a single ERISA welfare plan without creating a MIWA. It's rarely that simple, though. So anytime an employer considers allowing other employees to participate in its ERISA plan, it's important to get the employer's tax advisor involved to clarify which entities are in the controlled group. And many MIWAs are formed inadvertently, and the employer has no idea it's sponsoring a MIWA. This can happen during a merger or acquisition where the common interest between two companies can change literally overnight. It can also happen when non-employees are allowed to participate in an ERISA plan. For example, a company might feel generous in allowing its non-employee board members or independent contractors to participate in the ERISA plan, but that creates a MIWA. Most employers will want to avoid sponsoring a MIWA where possible because there are additional state and federal requirements for MIWAs. And those requirements are beyond the scope of today's talk, but just know that they're not necessarily simple. And if an employer finds itself in a situation where it has a MIWA, they should work with their tax counsel and legal counsel to determine the best way to approach that. So now let's take a look at the specific health and welfare programs that are regulated by ERISA. ERISA specifically lists different types of programs that, when they're sponsored by a private sector employer, are subject to ERISA's requirements. The first, ERISA regulates medical, surgical, and hospital benefits, and this includes any programs that provide or reimburse medical care. It also includes telemedicine, which would fall within that. It also includes pharmacy, dental, vision, health flexible spending accounts, health reimbursement arrangements, and employee assistance programs that provide counseling, and wellness programs that provide medical care or are related to the medical plan. Those are all ERISA benefits. For example, a wellness program that offers free biometric screenings or offers an incentive for employees to participate in healthy behavior and offers lower premiums to those who don't use tobacco or those kinds of things, those are subject to ERISA. And many large employers now offer on-site clinics to their employees, and if that clinic provides more than first aid or treatment of minor injuries, then it's a plan that's subject to ERISA. ERISA also regulates programs provided in the event of sickness, accident, disability, death, unemployment, and prepaid legal services. So this can include the life and disability programs of the employer, such as life benefits on the life of the employee, spouse, or dependent, accidental death and dismemberment, business travel accident, and long-term disability plans. Also, employer-provided daycare centers are ERISA plans, as are certain funded vacation benefits, though vacation pay is typically excluded, as I'll discuss in just a moment. And finally, programs that, as I mentioned, provide prepaid legal services. Those are also ERISA plans. ERISA also specifically exempts certain welfare programs, so they're not subject to ERISA. Voluntary plans are exempt when they meet the voluntary plan safe harbor, which I will discuss a bit more on the next slide. Non-U.S. based plans for non-resident aliens are excluded. These are typically expat plans that are sponsored outside the U.S. and cover non-U.S. residents. Benefits covered through normal payroll practices are also excluded. So these are vacation and PTO or sick pay benefits that are paid solely through the employer's general assets. Insured short-term disability benefits are regulated by ERISA, but if the short-term disability plan is self-insured and all benefits are paid through the employer's general assets, the short-term disability plan is exempt from ERISA. And plans established solely to comply with state disability or workers' compensation laws are excluded. For example, New York and New Jersey require employers to provide specific disability benefits for employees in those states, and if the employer's plan is limited to those mandated benefits for those individuals, the plan is not subject to ERISA. But if the disability plan offers more than the state mandated benefits or offers benefits to more individuals than just those New York or New Jersey employees, the plan would be subject to ERISA. The same is true for workers' compensation plans. If the workers' compensation plan is in place to comply with a state workers' compensation law, it's not subject to ERISA. And just a note for Texas employers, Texas allows employers to opt out of the workers' compensation system. So for those who opt out but then purchase their own workers' compensation insurance policy, that policy will be subject to ERISA because it's not required by the state. And I also want to point out some additional exceptions that are not specifically listed in the regulations. So cafeteria plans are exempt because they don't provide benefits in the event of sickness or disability, and they don't provide medical care. This can seem a little confusing, but a cafeteria plan is simply a vehicle for paying for premiums for certain benefits, including ERISA benefits, paying those premiums on a pre-tax basis. So the benefits paid for through the cafeteria plan may be subject to ERISA, but the cafeteria plan itself is not. Health savings accounts are rarely subject to ERISA, and that's because they are individual savings accounts that employees can take with them if they separate from their employer. And dependent care FSAs or DCAPs are excluded because they reimburse daycare expenses and not medical or disability expenses. Stop-loss policies are another example. They're rarely ERISA plans because most employers pay stop-loss policy premiums with their general assets, and rather than providing an employee benefit, they're actually insurance for the employer, not for the employee. Adoption assistance plans are excluded because they're not the type of plan regulated by ERISA, as are identity theft, pet insurance, and auto insurance. Finally, recall that on-site clinics that provide only first aid are exempt from ERISA, whereas on-site clinics that provide medical care or more than simply first aid are considered ERISA plans. So while many employer plans are regulated by ERISA, there are a number of exemptions to review with legal counsel or your compliance consultants to determine whether a specific program is subject to ERISA. Now, finally, I just want to go over the rules around the voluntary plan safe harbor. We get a lot of questions about this. So as I mentioned earlier, there is an exception for benefits that fall within the voluntary plan safe harbor, and those are not subject to all the ERISA requirements. The safe harbor is typically used for plans referred to as worksite benefits or voluntary benefits or employee pay all plans. They typically take the form of indemnity plans, cancer plans, or other supplemental benefits. And if a benefit falls within the safe harbor, the employer is not responsible for the compliance obligations under ERISA and various other federal laws. To meet the safe harbor, a certain number of criteria must be met. First, employee participation must be completely voluntary. The employer cannot contribute to the plan. The employer's involvement must be limited to collecting premiums and forwarding them to the insurer. The employer can receive only reasonable compensation for administrative tasks, and the employer cannot endorse the plans. So it sounds relatively easy when I just list those requirements, but that endorsement prong has a lot of factors, and employers should try to meet as many of those as possible to be able to argue that they meet the voluntary plan safe harbor. Endorsement can occur through a number of activities. If the employer acts with the intention of sponsoring the plan or conveys that to employees so they believe it's an employer-sponsored plan, then the employer could be considered to be endorsing the plan. Other activities such as holding annual enrollment simultaneously for the sponsored benefits and these voluntary benefits, or if the employer funds the benefit payments or pays for the benefit outright, the employer will be considered to be endorsing the plan. Additionally, assisting with claims or designing the plan's terms, or if an employer allows any pre-tax contributions for these voluntary benefits, then it will be considered to be an endorsement and will fall outside of the safe harbor. So if an insurer is offering these types of voluntary or worksite benefits to employees, it's important to review the requirements of the voluntary plan safe harbor to ensure the employer can avoid sponsorship of those programs if they choose to avoid compliance with ERISA. And that's not necessary. They can allow these benefits to fall under ERISA, but because there is an exemption available, sometimes employers want to take advantage of that. So in essence, the insurer needs to have control over the plan, and the employer's only involvement can be taking employee contributions and forwarding them to the insurer. It's always a good idea to discuss these benefits with counsel to ensure compliance with the safe harbor and to evaluate whether the employer wants them to fall within the safe harbor. And now I'll turn things over to Sally.
Thanks, Kim, for that background. Now that we've talked about which employers are subject to ERISA and which plans are subject to ERISA, and we've covered some basic definitions, it's time to get into the substantive requirements under ERISA that many of you know and either love or don't love, as the case may be. The first requirement is the need for a plan document. This is true for all plans, regardless of your size. There's no exception here for small plans. Although ERISA doesn't require that a plan document take a specific format, it does define the core elements that have to be included in that plan document. So the plan document will establish the plan year, the plan administrator, and the named fiduciary, which Andrew is going to be discussing later. It also will designate other people or entities for certain plan responsibilities, such as naming a third-party administrator, as an example, as the claims administrator, so that they can process claims for the plan. The plan document also is going to establish the plan's funding policy and how plan assets are handled. And here, when I talk about plan assets, I'm referring to participant contributions or trust funds for a funded plan. The document should also contain the claims procedures for the plan and your process to amend or terminate the plan. If the plan is subject to other federal mandates, such as COBRA or FMLA, then those are also going to need to be described in the plan document. And as Andrew is going to discuss later, ERISA imposes fiduciary responsibilities requiring the plan to be administered according to its written plan document. This plan document provides the roadmap on how you administer the plan. For example, if the plan administrator is not sure who was eligible for the plan, then that plan document is going to be the place where they look to and see what are the eligibility rules that it contains. So when establishing a plan and obtaining that written plan document, there are some important helpful tips to remember. First, there are plan documents that are referred to as wrap documents. These plan documents wrap together a menu of health and welfare benefits to create a single ERISA plan. For example, if you decide to offer a medical, dental, vision, life, and long-term disability coverages to your employees, well, ERISA technically requires a plan document for each one of those separate benefits. However, to ease the administrative tasks related to the Form 5500 reporting, you can adopt a wrap plan document that it's going to wrap around all of those health and welfare benefits to create one single large ERISA plan that contains all those component benefits. This in turn is then going to reduce the number of Forms 5500 that must be filed from 5 5500s down to just a single 5500. The second tip involves HIPAA. While HIPAA is really outside the scope of this presentation, I did think that I'd mention that HIPAA privacy rules require that the plan sponsor amend their health plans to ensure that the plan sponsor will abide by HIPAA privacy standards when reviewing protected health information. Any written plan document or wrap document should also typically include this HIPAA amendment. So in a way, complying with the ERISA plan document requirement is necessary and will help the employer meet one part of their HIPAA compliance requirements. You not only need a plan document, you also need a summary plan description, or what's referred to as an SPD. An SPD is essentially the plan document, but written in plain language to be understood by the average plan participant. The Department of Labor requires certain content in the SPD that may differ slightly from the plan document, and I've shown those requirements here on the slide. Essentially, these content requirements are meant to help a participant understand their rights and obligations under the plan. Many employers just use the documents provided by the carriers or the insurers as the SPD. However, that's not really foolproof because the carrier documents are not written to comply with ERISA. Those documents often don't contain all of the SPD content requirements that are listed here on the slide. Much like how the plan document can be a wrap plan document, an SPD can also take on the form of a wrap SPD. So that wrap SPD provides much of the content requirements that really are missing from the carrier and insurer provided documents. And like the wrap plan document, it's going to wrap around all those employer health and welfare benefits. And typically, when you engage a vendor to draft your wrap plan document, that vendor is also going to include a wrap SPD at the same time. ERISA has a number of participant disclosure requirements, and I know keeping track of all of the different deadlines can really start to make your head spin, so let's just walk through these today. The SPD itself has to be provided to participants in specific timeframes. For example, when a participant first enrolls in a plan, the SPD must be provided within 90 days from being covered by the plan. If a plan sponsor decides to establish a new plan, that SPD must be provided within 120 days to all participants. Otherwise, outside of those two timeframes, the SPD must be provided at least every 5 years if there have been material changes to the plan, and every 10 years if there were no material changes during that time. Practically, plans change just about every year or two now, and because of those changes, often you'll want to use what's called a summary of material modification, or an SMM, or a summary of material reduction, which is called an SMR, to disclose those changes versus a full new summary plan description. The SMM is used to communicate positive or neutral modifications to the plan. For example, if the medical plan insurer is your only change from one plan year to the next, you can disclose an entirely new SPD with that information in it, or you can just issue a short SMM to communicate just that change. The SMM must be disclosed within, get this, 210 days after the end of the plan year in which the change took effect. I did say that correctly. That's a very long time and can result in you not communicating the change until the year after the change takes place. So, doesn't make any sense. Much better practice to provide the information before or soon after the change rather than waiting until the end of that full deadline. That way participants really understand the change when it's actually happening. And you're usually going to be doing that in employee open enrollment materials more than likely. The SMR is used to communicate material reductions in benefits. What rises to the level of being a material reduction, you ask? Well, that's not defined in the regulations and really is based on facts and circumstances and whether an average plan participant would believe it was a material reduction. In practice, many employers choose to judge any reduction in benefits as material and choose to meet the shortened time frame for the SMR. The summary of material reduction must be given within 60 days after the decision to amend the plan. So like the SMM, a new full SPD can be reissued in place of that short SMR, but that shortened time frame can sometimes make that difficult to accomplish. The final disclosure is the Summary Annual Report, or the SAR. The SAR is a summary of what the plan reported on its most recent Form 5500. Self-insured, unfunded ERISA plans are not required to disclose an SAR. Also, as we are going to discuss later, some small group plans are exempt from the 5500 filing, making them exempt from the SAR requirement too, but they still need to do a plan document. The SAR should be disclosed within 9 months after the end of the plan year, or if you file an extension for the Form 5500, then within 2 months after that extended due date. Now, so far we've talked about the type of disclosure and when they need to be disclosed, but we haven't discussed the method of disclosing the information to participants. ERISA requires that the method of disclosure should be reasonably calculated to ensure actual receipt. The default method of disclosure is always first-class mail to the last known address of the participant or the beneficiary. Keep in mind that these disclosure rules were issued more than a decade ago, and our day-to-day lives were way different back then. Fewer people had access to the internet, and even fewer had smartphones. Also, efforts to recycle and curb paper usage were just getting underway. The Department of Labor has recently updated those disclosure requirements for ERISA retirement plans, and so we're really hopeful that they'll soon be updated for health and welfare plans as well. But in the meantime, though the default is still first-class mail, it's possible to follow a safe harbor and disclose electronically and still be in compliance. Careful compliance with these rules is important because if the method of disclosure fails to meet those standards, then the disclosure itself is not considered quote-unquote sent. And that failure can result in complaints to the Department of Labor or penalties. So if employees have access to the employer's electronic system as an integral part of their job duties, think a laptop or a desktop computer that's been provided to them, then the plan administrator can disclose to those employees electronically without seeking consent first. There are additional rules and best practices even for this group of employees, though. For example, if the items will be disclosed via a website, like the Benefits Administration website that you may have set up, then you can't just stick it on the site and be done. You're going to really need to provide notice to these employees so that they're aware of the disclosure being posted and where they need to go to that site to get it and know where to go for more information so that they're really reading this and considering it to be an important part of their communications. For employees who do not have access to the employer's electronic system as an integral part of their job, you have a choice. You can either provide the disclosures via first-class mail to the employee's address, or you can obtain their prior consent to disclose plan information electronically. That consent should be designed in such a way to prove the ability to access the electronic means. So many employers are going to build those consent forms into their benefit administration system. And then when the employee logs in to enroll and consent to the benefits, the plan administrator can prove their ability to access the site. When you are analyzing, though, whether to disclose on an electronic basis, really take some extra thought to see where really the participants are going to be able to access the information at the time that you're giving it to them. Further steps can be put in place to obtain those consents, as we've discussed, but many times this group will still be best served by receiving paper communications via their last known address. Remember, the goal of these rules is to provide the information to participants by a method they can access so that they know what the benefits are being offered and how to use those benefits. This is a great benefit that you're offering them, and we want them to be aware of it. Another important required disclosure is when participants request access to documents. Participants or their authorized representatives, lawyers like me, have the ability to request the plan document, the summary plan description, the most recently filed Form 5500, and any collective bargaining agreements that may contain plan provisions, or really any other instrument that is used to establish or maintain the plan. If the written request is part of a claim or an appeal of a claim, then the participant may also request documents relevant to that claim. Most frequently, when a document request occurs, a claim has probably already been denied, or potentially the participant is considering making a complaint to the Department of Labor or filing a lawsuit. So it's important to, one, have those documents readily available in case of a request such as that, and two, understand that you have only 30 calendar days to respond with that documentation. Failing to do so can result in penalties of up to $110 per day, so you want to have the plan documentation readily available to be able to be provided. Now let's move to a different requirement under ERISA, reporting. ERISA plans are required to report certain administrative and financial information about the plan. Each plan is going to be subject to that 5500 requirement unless you meet the small plan exception. Under that exception, a plan does not have to file for a plan year in which there were less than 100 covered participants at the beginning of the plan year, and the plan is fully insured, unfunded, or both. Here, when we talk about a funded plan, we mean that there's probably a trust holding those participant contributions, and potentially employer funds are included in that trust to exclusively pay those plan benefits. An unfunded plan means that the employer pays benefits from their general assets and no benefits trust actually exists. So to meet that small plan exception, a plan administrator would look at the covered participants, which includes the COBRA qualified beneficiaries, but not any spouses or dependents. If the plan is under 100 covered participants on day one of the plan year, and the plan is fully insured or unfunded or both, then a Form 5500 does not need to be filed for that plan year. But you do still need to do that plan document. I'm just going to keep saying that. There's an exception to that small employer exception that we just talked about, though. If the plan is a multiple employer welfare arrangement or a MIWA, as Kim was discussing earlier, or it's a funded plan because it has a trust, then no matter the size, the plan must file each plan year. For plans that are fully insured, you're going to have a Schedule A that you also need to file with that Form 5500 for each one of the benefits. The Schedule A reports specific details about the fully insured plan, including the premiums and the commissions paid on behalf of the plan. And the insurer is typically going to provide the Schedule A information to be included with that Form 5500 reporting. Plans that have a benefits trust will also need to grapple with additional schedules to report payments to plan vendors and detailed financial data about the plan and the trust, including the requirement to obtain an accountant's opinion, which requires an audit of the plan's financial records. The Form 5500 is due 7 months after the end of the plan year. So for plan years that run on a calendar year basis, January 1 to December 31, that Form 5500 is due at the end of July each year. Plans may also file a Form 5558 to extend that deadline an extra 2.5 months, making the due date for a calendar year plan October 15th. An automatic extension can also be granted to the due date of the employer's federal income tax return if you satisfy certain conditions. If a benefit plan has failed to comply with the Form 5500 filing requirements, there is a way to reduce potential liability and come into compliance but only if the plan has not been audited or penalized for delinquent filings. So the Department of Labor created a program to encourage plan administrators to file overdue annual Form 5500 reports, and that program is called the Delinquent Filer Voluntary Compliance Program, or DFVC. The DFVC program allows health and welfare plans to complete that overdue Form 5500 filing and pay substantially reduced penalties. So don't ignore or delay those 5500 filings if you find that they've not been handled timely, because there is this program that will really reduce their penalties if you take care of it before the Department of Labor finds out. Another requirement for ERISA plans is to establish and maintain a reasonable process that allows participants to dispute their benefit entitlements or any claim denials they've received. The process is meant to protect a participant's promised benefits. To that end, there are specific requirements that we really need to follow that provide timelines to submit a claim or file an appeal of an adverse benefit determination. A participant or their authorized representative may appeal that determination. The process must also allow for requests for documentation on those denials. There are variations between the requirements based on the different type of ERISA plan and based on the urgency of the determination. So for example, an appeal for a group health plan versus a life plan versus a disability plan will be processed in different ways and with different time frames. But in all cases, the goal is to have really the opportunity for a full and fair review of that participant's claim. Often, because the claims and appeals process can be time-consuming and requires access to medical experts, insurers and third-party administrators really often serve as the entity that will administer the plan's claim and appeal process, and they may take on that ERISA fiduciary obligation for that process. For self-insured plans, it's very important to include who has that claims fiduciary responsibility within the administrative services agreement with that carrier or TPA. Andrew's going to be discussing the importance of this role further in his discussion of ERISA fiduciary responsibilities, so I'll leave it at that for right now. I know that I've covered a great number of reporting and disclosure requirements in a short amount of time, and Kim's giving you that background. And you may also realize that the devil is really in all of these little details. So we have some great resources that may help you implement all of these requirements in a compliant manner. ERISA is only one of the topics that we cover in our foundational Back to Basics webinar series. It also includes a really nice ERISA guide that provides more details on each one of the topics that we've already discussed. You can find these links to the resources in the event portal for today. So with that, Andrew, I'm going to hand off to you now to further discuss the importance of ERISA preemption and fiduciary duties when administering all of the group employee benefit programs and where we are headed with all of these obligations.
Okay, thanks, Sally. So as everyone can probably tell, ERISA already provides really a large number of rules that plan sponsors have to follow. But the quid pro quo for that obligation is a corresponding benefit that ERISA plans are generally not subject to state laws that regulate employee benefit plans. Now, there are some nuances to that, which is why we'll spend some time now on ERISA preemption. Okay, so yeah, I know this slide is a little bit of legalese. We really try to stay away from that, but I want to lay a foundation so you can have really a basic understanding of how ERISA preemption works, because you've probably heard that term before, but you've never actually seen what ERISA says. The basic general rule is that ERISA preempts state laws that relate to any employee benefit plan described in ERISA. That's from 514A of ERISA. So what does preempt mean? That means it prevents or prohibits the state law from regulating the ERISA plan. It's another way of telling states, stay in your lane. There are a lot of things you get to regulate as a state, but ERISA plans are not one of them. The biggest exception to that rule really comes from the Savings Clause, Section 514B2A. That states that ERISA does not preempt state law which regulates insurance or banking or securities. In other words, states still get to pass laws and enforce those laws against insurance carriers and the products that insurance carriers can offer in the state. So if you have a fully insured plan, the policy that you bought from your carrier is regulated by state law. The carrier had to have that policy approved by the state, and it already follows state insurance mandates. And ERISA allows that to happen through the savings clause. Okay, next we get a clause that prevents states really from being too cute in how they define insurance. Like I just said, states get to regulate insurance, but 514b2b prevents states from treating employee benefit plans themselves as if they are insurance companies. In other words, employee benefit plans are not deemed to be insurance companies. And as a result, employee benefit plans are protected from direct regulation by the state. So, for example, this means that self-insured plans are not engaged in the business of insurance, and states do not get to regulate them as if they were. As a practical matter, this really means that self-insured ERISA plans have more flexibility in plan design than fully insured plans do. As a side note, there are even further complications and nuances when we consider multiple employer welfare arrangements, or MEWAs. MEWAs, again, like Kim said earlier, are plans that cover unrelated entities that aren't part of the same controlled group. And in 1983, Congress amended ERISA to authorize further state regulation of MEWAs, primarily to counter abuse by what they called operators of bogus insurance trusts who were avoiding state investigations and enforcement. And as a result, states can and often do impose a lot of additional requirements on MEWAs, such as organizational requirements and trust requirements, reporting requirements, and other restrictions. So those are the basic rules. Also, some litigation benefits are provided under ERISA. Specifically, federal courts generally have exclusive jurisdiction over some types of ERISA claims, such as breach of fiduciary duty. Other ERISA actions, such as an action to recover benefits under the terms of an ERISA plan, could be litigated in either state or federal court since they have concurrent jurisdiction, but often defendants would simply make a motion to remove the case to federal court. Okay, so how does ERISA preemption play out in the world we live in? Let me give you some examples. Let's say that there's a new state law that imposed a plan design coverage mandate. For example, a state law that requires plans to cover in vitro fertilization expenses for a covered participant. Maybe that state law also has some other conditions on the treatment, like it requires a history of infertility. And would that law be preempted? Well, yes, for employers subject to ERISA, since it relates to the very design of an ERISA plan, namely what's covered and what isn't. Of course, if the employer has a fully insured plan, the state still gets to regulate insurance, and there are several states that do include a mandate for insurance policies issued by carriers to include IVF coverage. So if you're fully insured in that type of state, then your choice to cover IVF or not might already be made for you when you bought the policy from the carrier. Okay, what about a state law requiring continuation of health coverage following a loss of eligibility? Well, of course you all know about COBRA, but also most states have a state continuation law that applies to fully insured plans issued in that state. And a select few of those state laws also apply to COBRA covered employers. And they can even tack on an additional state law continuation right that goes beyond the normal 18 months of COBRA. So for example, Texas has a state continuation law that tacks on an additional 6 months of state continuation beyond the 18 months of COBRA. So if you have a fully insured plan in Texas, that insurance policy can be regulated by the state, and the policy will include and will have to include the state continuation right. Alternatively, if you have a self-insured plan, those state continuation laws could not apply due to ERISA preemption. What about a state law requiring health plans to report claims information to an all-payer claims database? At first, that seems like it might be a closer case since it doesn't regulate benefit design or eligibility, for example. But ERISA doesn't just protect plan design. It also has really a distinct and voluminous governmental reporting structure. So state laws that impose this type of additional reporting obligation can be preempted as well. And we have a Supreme Court case on that very topic from 2016 that concluded that all payer claims database laws cannot require self-insured ERISA plans to submit this information. What about a state law requiring PBMs to pay pharmacies no less than their acquisition costs for prescription drugs? Well, that has an effect on plan costs. Shouldn't that be preempted? Unfortunately, no, that's not preempted. That's an Arkansas law that the Supreme Court decided was not preempted in 2020. They concluded that the law only had an indirect economic influence on plans. It was mere cost regulation, so not preempted. In that case, it was called Rutledge v. PCMA, kind of opened the door to other state legislation affecting PBMs. And it's not always clear whether those laws are preempted. For example, in the last bullet, we described an Oklahoma state law that heavily regulated PBMs by establishing geographic parameters for PBM networks, by prohibiting PBMs from incentivizing in-network pharmacies, and by requiring PBMs to accept pharmacies into their preferred network. And that law was originally upheld at the federal trial court level, but last year the 10th Circuit Court of Appeals found that it was preempted by ERISA, and that case is called PCMA v. Mulready. And it's not over since a petition for cert was filed in that case with the U.S. Supreme Court. So overall, it's a pretty complicated area and a developing area as well. Okay, so how do we analyze the issue holistically? Because it seems certain that state regulation is going to continue, especially around PBMs. First, when a new law comes down, start with the basics. Is your plan fully insured or is it self-insured? In many cases, that will tell you all you need to know on whether the law impacts your plan or doesn't. Separately, if you happen to have a MEWA, then bear in mind that there will be a wider range of state rules that might apply to your plan. Second, consider the context of the law and who it aims to regulate. For example, the law might not regulate plans directly, but instead might regulate an entity that states actually have jurisdiction to license and regulate. So if the law regulates your PBM, that's the most important party in the equation. And you'll want to get your PBM's take on the law first and how they intend to comply with it. The PBM might not want to risk their license, so that might force their hand and practically your hand on certain plan choices that are implicated by the law. And then finally, when discussing with your legal counsel, I don't think the question should always be as simple as, yes or no, is the law preempted? Now, for some older state laws or clearer state laws, it might be that simple, but often it's pretty complicated. You'll want to consider the likelihood that the law might be preempted or not based on your particular jurisdiction. Not all federal circuits are identical. And depending on how new the state law is, you'll want information on whether there are any existing challenges to that law already and how have they turned out so far and how far up the federal court system have they gone. Because someone else might be fighting the fight that you want to fight. So you want to know how that has turned out. And then finally, if you want to and are able to stake out a position that you're not going to follow a particular state law, what are the risks? In other words, is that state law actually being enforced? And if so, what are the potential enforcement results from the state? Okay, let's shift gears to another fundamental set of rules under ERISA, which are the obligations imposed on plan fiduciaries. This isn't new, of course. ERISA fiduciary duties have been around since the law was passed, but we'll get into some new developments in this area as well. First off, who is a fiduciary under your plan? Let's have a named fiduciary identified in the plan documents. It also has to have any number of functional fiduciaries based on really the tasks that they perform for the plan. So the named fiduciary is often simply listed as the employer, and alternatively, some plan sponsors might delegate fiduciary tasks to an individual or a committee, and sometimes that individual or committee will be the named fiduciary in the written plan document, an SPD. As for functional fiduciaries, this would include anyone who exercises discretionary authority or control over plan administration or management, or who has authority or control over the management or disposition of plan assets, or who renders investment advice for a fee, And keep in mind that the majority of health and welfare plans don't have investments that are regulated by ERISA fiduciary duty rules. Instead, they just pay premiums to a carrier in a fully insured plan, or if they're self-insured, they pay benefits and administrative expenses out of the general assets of the employer. In any event, functional fiduciaries might include both members of the employer's workforce that are involved in plan administrative decisions, but also third parties to whom certain fiduciary tasks have been delegated. So for example, a TPA that provides claims processing services would be a fiduciary if it has discretionary authority over administering claims. But not all service providers for the plan are fiduciaries under ERISA. Remember, it's a functional definition. There are a range of employees of the plan sponsor and vendors that perform tasks for the plan or the plan sponsor that aren't functional fiduciaries because they aren't exercising any discretionary authority over plan administration. They might perform their job with the utmost skill and hold themselves to the highest standards, but that alone doesn't make them ERISA fiduciaries. Okay, and similarly, not all plan decisions are fiduciary decisions. For example, even though the employer is likely a plan fiduciary because it's identified as the plan administrator or the named fiduciary in the plan documents, it will not be treated as a fiduciary when it does certain things like adopting a plan, amending a plan, or terminating a plan. The courts have recognized that there are certain business activities contrasted with plan administration and management that aren't subject to ERISA's fiduciary duty rules. So things like choosing or changing benefit options or setting or changing the required levels of employee contributions. Those are business decisions or settler functions that are exempt from ERISA fiduciary duty rules. Now, those are still important decisions. You want to make sure that you're offering a benefit program that meets your business goals and finances. And there's a lot of careful planning and data analysis and benchmarking involved in that process. But that decision-making process wouldn't be subjected to specifically fiduciary duty rules under ERISA. It's also worth noting that a variety of individuals perform ministerial functions for the plan that are not fiduciary in nature. And this might include collecting employee salary reduction contributions as provided in the plan documents, or applying plan eligibility rules for purposes of simply offering benefits and conducting annual enrollment. No discretionary authority or control is really involved in those decisions. But if a decision is a fiduciary decision, what standards apply to it? It would be these: the duty of loyalty, duty of prudence, the duty to diversify plan investments. Again, if there are any plan investments or plan assets that are invested, that's really more typically the case in retirement plans, and the duty to follow plan documents. So as a more practical matter, how do these fiduciary obligations actually impact the plan administrative decisions you make? So let's think about some examples. Let's say that an employer sponsors a health FSA subject to ERISA, and at the end of the year, the benefits manager has to decide how to deal with remaining FSA forfeitures for that year. Those are plan assets under the duty of loyalty and the exclusive benefit rule of ERISA. These plan assets have to be used for the exclusive benefit of participants and beneficiaries under the plan. So it would be acceptable to use those forfeitures to pay for the plan's reasonable administrative expenses to the health FSA vendor, for example. It would not be acceptable, and it would be a breach of the duty of loyalty to use those funds to buy a new laser printer for the HR department instead. Okay, another example. Let's say that a self-insured plan wants to carve out its pharmacy management to a separate PBM. So what does the plan do? It decides to have a documented RFP that includes multiple possible vendors and provides consistent questions and requirements and processes for those vendors. The plan fiduciaries then engage in a thoughtful, deliberate selection process to compare the responses and the fees for each of the vendors. They select the best quality vendor that can deliver services for a reasonable fee. And after that, the plan fiduciaries monitor the vendor's performance to ensure they're providing the PBM services according to the terms of their contract. That would be a decision-making and monitoring process that matches up really well with the ERISA duty of prudence, or the prudent expert rule. Okay, and one more example. Let's say that a plan defines its plan eligibility criteria to include full-time employees who work 30 hours per week. That's who's eligible. The benefits manager has identified a key independent contractor who isn't a common law employee of the organization, doesn't work 30 hours per week as an employee, but they're considered really an important piece of the business's operations, so the benefits manager offers them coverage under the employer's group health plan. That would be a failure to follow the terms of the plan documents and a breach of fiduciary duty. And really, as a practical matter, they'll have some more clear and present danger issues besides ERISA, since the carrier isn't going to provide coverage for someone who isn't eligible under plan terms. So follow the plan documents. So really, as you can see, there are a number of decisions that have fiduciary implications, both big and small. With this webinar, we're actually releasing an ERISA fiduciary governance toolkit that goes into much more detail about who the plan's fiduciaries are, what is the best way to mitigate fiduciary risk, what should you consider for fiduciary governance structure, and what are the considerations for prudent fiduciary oversight of your health and welfare plans. So we invite you to review those materials further. But to sum up, consider the following really 3 best practices. First, consider who will actually have decision-making authority on matters of plan administration, both inside your organization, within your own workforce members, as well as third parties that you delegate fiduciary tasks to. Second, understand and follow your plan documents religiously, including provisions regarding plan eligibility, benefits, and claims, although keeping in mind that you're probably delegating claims administration responsibilities to someone with expertise in that process, namely your carrier or TPA. And then finally, with respect to plan administration, including the selection and monitoring of plan vendors, and also the use of plan assets as well, don't forget that, engage in a thoughtful process with respect to how you make decisions, really keeping in mind a lot of factors, but the duty of loyalty and acting on behalf of the plan for the exclusive benefit of plan participants and beneficiaries. Fiduciary duties have really come to the forefront lately due to some recent litigation. So let's close out the webinar now talking about that litigation, as well as some long-standing enforcement efforts of the administrative agency that enforces ERISA, namely the DOL. Specifically, you've probably heard about the case of Lewandowski versus Johnson & Johnson because it made mainstream media. And it involves really a high-profile defendant, and it has some fairly interesting arguments. So in the Johnson & Johnson case, a complaint was filed on February 5th, and that complaint alleges that Johnson & Johnson violated its fiduciary duties under ERISA. Specifically, the plaintiff alleges that this breach of fiduciary duty of prudence was most evident in the prices that the plan agreed to pay its PBM for generic drugs that are widely available at drastically lower prices. For example, in the complaint, the plaintiff identified one generic drug that was available at some large pharmacy chains for around $40, and which they allege the PBM charged the plan $10,000. So the plaintiffs allege that that type of drug markup harms the plan and the participants in the plan, who of course have their own cost-sharing requirement for those prescription drugs. So, is the case over? No way. It gets litigated now. The defendants already filed a motion to dismiss the complaint on April 19th, and in that motion, the defendants made some initial arguments stating that the plaintiff didn't even have standing to bring the suit. But on a more substantive level, the defendants argued that the complaint didn't state a valid claim, and that plaintiff would have needed to allege that the plan's fiduciary process for choosing a PBM and negotiating drug prices was not prudent. And the defendants argued that it was not enough to simply point to a fraction of the plan's covered drugs and claim they were too expensive. And then in response, the plaintiff was allowed to file an amended complaint in an attempt to cure the initial defects that the defendants identified. So we don't know how this case will turn out, but it is one example to show that, yes, sometimes plan fiduciaries' decisions can be challenged. They can be challenged in court. And win or lose, it's certainly frustrating and expensive to have to defend a fiduciary lawsuit. Does this case establish a brand new rule that changes how all employers operate their plan and conduct RFPs and contract with PBMs? Well, no, but as with any litigation, we'll observe how it plays out, we learn from it, we refine best practices if necessary, and then, keep in mind that significant litigation and legal precedent can eventually alter what is recognized as the standard of care for fiduciaries. Some employers may have reviewed the Johnson & Johnson lawsuit and maybe had a wake-up call on their decision-making process, or really lack thereof, for selecting and contracting with PBMs in particular. But a lot of other employers probably thought to themselves, well, we already have a sound and really painstaking process for selecting our PBM. We negotiated the best deal that we could based on what the PBM market has available. And this case really reinforces why we went through all of that. And a number of employers have begun considering whether it would be appropriate to form a benefit committee. And that's certainly a hot topic. It's reached the zeitgeist among practitioners. Of course, forming a committee isn't a silver bullet that stops litigation in its tracks. In fact, Johnson & Johnson had a committee. That committee was a defendant in the lawsuit, although the individual defendants were removed from the amended complaint. But for at least some organizations, a committee might be a good idea to strengthen your process for vendor selection and monitoring. That assumes you actually keep up with the committee responsibilities and meet regularly and act in the best interests of plan participants and beneficiaries, and act in accordance with whatever charter or bylaws you have for your committee. With this webinar, again, we're releasing some additional consideration pieces on committee formation and responsibilities, which we think will be helpful if you want to go that route. Apart from litigation and the right for participants to sue to recover benefits or for breach of fiduciary duty, ERISA vests the DOL, specifically the Employee Benefit Security Administration, or EBSA, with the authority to enforce the provisions of ERISA, and that can include some significant penalties for ERISA failures. So, for example, as we discussed earlier, ERISA plans have a Form 5500 reporting obligation each year unless they meet the terms of the small plan exemption. And the DOL still actively polices that requirement and still sends penalty letters to employers who had a duty to file and didn't. So again, don't forget about that small employer exemption. But if you don't meet the terms of the exemption for a particular year and you really need to think about using the DFVC process that Sally mentioned earlier to avoid much larger penalties for non-filers. Similarly, investigations of plans for ERISA and ACA failures continues. So are your chances of an audit high? Well, I mean, based on the most recent fact sheet, EBSA has enforcement authority over approximately 2.8 million health plans and 619,000 other welfare benefit plans, and that's a lot. They don't have that many investigators, so not everyone is audited. But let me say this, hope is not a strategy. In this day and age, participants have internet access. They can research and find out their rights under ERISA really easily. And EBSA does pursue investigations of plans based on participant complaints. So if you have major compliance issues and even one angry participant, your chances of an investigation increase by a lot. Finally, and more recently, the DOL has conducted inquiries concerning health plan compliance with mental health parity rules. Plans are now required to have an analysis performed of any non-quantitative treatment limitations, or NQTLs, that they might have on mental health and substance use disorder benefits. And they're required to demonstrate in that analysis that those NQTLs meet parity standards when compared to the plan's medical and surgical benefits. And even in advance of the final regulations, the DOL had the authority to and did request a copy of the plan's analysis, and in some cases required plans to take corrective action to cure any NQTL deficiencies that they had. And those reviews are going to continue. Those are the basic considerations. And to sum things up, first, whether you form a benefit committee or not, consider whether your process for making plan decisions is prudent, that you have a process in the first place, and that you're selecting plan vendors for the right reasons using careful analysis, and that you're monitoring their performance, being good stewards of your plan. And pay attention to litigation that's out there. We'll see how it develops. And then finally, from a more general compliance standpoint, conduct periodic compliance reviews to see if there are any gaps that might cause risk, and prepare for more extensive enforcement and litigation involving mental health parity rules in particular. And that wraps up our webinar. So thanks again to Sally and Kim for sharing your expertise with us today, and thanks to our listeners for joining us. And you all know that compliance tends to be a moving target, so keep your eye out to our Gallagher newsletters and alerts for ongoing information as well. And have a great rest of your day.